Hey there, I'm the MadCatster. Mike, glad to see you here. Well, Jack Doherty has been talked about on social media a lot lately, most recently because he allegedly idiotically was texting and driving on the highway at high speed, and he totaled his McClaren, injured his friend. But then a year ago, his bodyguard appeared to sucker punch a bystander in the crowd at a party that Jack was at. And of course, that's now led to a lawsuit which was filed earlier this year. Well, Jack Doherty has responded to that lawsuit, and I can only describe the answer as idiotic and ridiculous. So I'm going to go over it with you right now, and you can see exactly what I'm talking about in terms of stupidity. You know me, I've got the dates and all the receipts, so buckle up and let's go. Welcome, you guys. So today I'm here with Cedric, my faithful sidekick, and Clarice and Squirt are here too. They're walking around over there. Like and subscribe, please. And we're going to talk today about that cockroach of social media, as I affectionately call him, Jack Doherty, who has become basically one of the most hated people on social media. And recently, the stupidity rose to a new level when he was live streaming himself, driving his McClaren at high speed on the highway, apparently using his phone to text or something with the stream, and crashed and basically totaled the McClaren. Also injured his friend who required stitches. And basically he's lucky that he didn't end both of their lives. But this is like a pattern of really crappy behavior by him. And a year ago, his bodyguard, and he came under fire because his bodyguard had allegedly sucker punched somebody who was there at a party that Jack was attending. And, you know, this was all caught on video, and Jack Doherty was basically being really obnoxious to this group of people and saying that he was going to fight them and all this stuff. And out of nowhere, the bodyguard just decks this one guy. So now this guy, of course, is suing, and the lawsuit was filed earlier this year. Jack Doherty responded with his answer to the lawsuit. It's absolutely ridiculous. We're going to go over it. You can see exactly what I mean. It's just absolute nonsense. We're going to just briefly touch on the lawsuit to go over just the basic facts, and then we'll move on to his ridiculous answer. So here you'll see this lawsuit was filed in the Superior Court of Los Angeles County, and it's Chase Cameron Gardella, who's the plaintiff, against Jack Doherty LLC, Banger Official LLC, Kong Inc., Jack Doherty, an individual, Justin Gosley, aka Kane Kong, an individual, and Does 1 through 50 inclusive. We talked about the fact that Does are sometimes included because there are going to be potential additional defendants that at the time of filing haven't been identified yet, so they may have more people they're going to name and bring into this suit. But I'm assuming that Justin Gosley is the bodyguard. So you can see here the complaint for damages is for assault, battery, negligence, negligent hiring, retention, supervision, training, aiding and abetting, and intentional infliction of emotional distress. And of course, there's a demand for a jury trial. And here are the general allegations. It says on October 28, 2023, plaintiff was attending a Halloween party. At approximately 12:30 a.m. on the morning of October 29, 2023, plaintiff was on the street outside the subject premises and was talking to Doherty and Gosley. At one point in the conversation, Gosley asked Doherty, "What are we doing?" And Doherty said, "We're going to fight. Us two versus you two. All right, go." And gestured that he and Gosley were going to fight plaintiff and plaintiff's friend. Moments later, Gosley violently punched plaintiff in the face, sending him falling to the ground and causing serious physical injuries to his head, face, and neck. The amount in controversy is greater than $75,000, and that's what it has to be in order to be in federal court. It's got to be more than $75,000 that you expect to get in damages. Plaintiff did not consent to Gosley's conduct. Doherty live streamed the assault on plaintiff on the live streaming platform Kick, and in the hours and days that followed, posted videos of the assault to his YouTube, X.com, and TikTok channels, where he has a combined 22.8 million followers. Doherty has and continues to generate income due to the many views the video has received, all to plaintiff's detriment. Doherty has a history both before and after the subject incident of filming himself harassing, assaulting, and antagonizing members of the public by having his security guards step in to intimidate and assault them if they react to Doherty's harassment. And we've seen that in videos. If you've ever seen clips of him, like there's one that was going around not that long ago. He's walking through the mall and he's basically like hitting people with his elbows. And when they react to him and confront him, he steps aside and lets the bodyguard step in because, you know, he's such a big man that he has to have other people take care of his business. And he continues, Gosley has a long history of assault and battery, including assault and battery in Broward County, Florida. 2 instances of assault and battery while working as a security guard for Jonathan Lindale Kirk, a.k.a. DaBaby. Doherty was aware of Gosley's prior assault and battery while working for DaBaby and ratified Gosley's assault and battery of plaintiff by paying him $5,000. So I'm guessing he got $5,000 for working that night. So here are the cause of action. I'm not going to read through them. I'm just going to read the headings. So the first is assault against all defendants. The second is battery against all defendants. The third is negligence against all defendants. The fourth is negligent hiring, retention, supervision, training against Jack Doherty LLC, Banger Official LLC, and Does 1 through 50. So basically, as the bodyguard's employer, he's saying that Jack Doherty's companies are liable for the conduct of the employee. The employee did something wrong during the course of doing his job. You can sometimes impute liability on the employer. And the fifth cause of action is aiding and abetting a tort against Jack Doherty LLC, Banger Official LLC, and Does 1 through 50. Defendant Doherty's actions, including giving substantial assistance and encouragement to Gosley when he said, "We're going to fight, us two versus you two, all right, go," were despicable, done with willful disregard to plaintiff's safety and intent to cause plaintiff injury. Consequently, Doherty is subject to punitive damages as set forth in the California Civil Code. Defendant Doherty had advanced knowledge of the unfitness of Gosley, employed him with a conscious disregard of the rights and safety of others, including plaintiff, and ratified his wrongful conduct by aiding and abetting his assault and battery of plaintiff, live streaming the assault for profit, and posting video of the assault to social media for profit. Defendant Doherty's actions were done in the course and scope of his employment for and in his capacity as officer of Jack Doherty LLC and Banger Official LLC. Consequently, Jack Doherty LLC and Banger Official LLC are subject to punitive damages as set forth in the California Code. And the sixth cause of action is intentional infliction of emotional distress. And as we've discussed, proving emotional distress is very hard and it's a very high bar. So we'll have to see if the jury thinks that the manner in which this happened and the fact that it was being live streamed, if that rises to a level that's outrageous enough for them to give him infliction of emotional distress damages. And the prayer for relief is plaintiff prays judgment against all defendants as follows: for general damages in a sum according to proof at time of trial, for special damages in a sum according to proof at time of trial, for punitive damages, for prejudgment interest according to proof, for costs of suit incurred herein according to proof, and for such other and further relief as the court may deem just and proper. So it's a pretty straightforward complaint. It's very clear that what happened and the fact that it certainly wasn't self-defense. And you're going to see in the answer some of the craziness that they're alleging as to why this guy's lawsuit should fail. So now let's move on and take a look at the answer. Incidentally, as a result of the car incident recently, Kick did ban him. Now, I don't know what's going on, whether they're in talks about reinstating him. I mean, the way these things have gone, I'm not going to be shocked if he gets reinstated. It's all about money after all. And I'm kind of actually surprised that they didn't ban him for live streaming the bodyguard sucker punching that guy. But so here's the answer. Superior Court of Los Angeles, and it's defendant Jack Doherty LLC, Banger Official LLC, and Jack Doherty's answer to the complaint of plaintiff Chase Cameron Gardella. So it's interesting that this answer is just on behalf of Jack Doherty and his companies. It's not on behalf of Kane Kong, even though he is one of the named defendants. So I would expect then that Kane Kong is going to file his own answer. I haven't seen anything on the docket yet, but I'll keep an eye out for it. But here we go. So defendant Jack Doherty LLC, Banger Official LLC, and Jack Doherty, collectively defendants, respond to the unverified complaint of plaintiff Chase Cameron Gardella. Plaintiff as follows. Unverified, like usually the plaintiff will sign an affidavit as to the accuracy and truth of what's in the complaint. There is no affidavit, so that's why they're calling it unverified, because when there's an affidavit, it's usually called a verified complaint. Pursuant to the Code of Civil Procedure, the answering defendants deny generally and specifically each and every allegation of the complaint, and further deny that plaintiff suffered injury or damage in the amounts alleged or in any other amounts or at all as a result of any act, omission, or other fault of the answering defendants. It's kind of rich. As separate, distinct, and affirmative defenses to the complaint, the answering defendants allege as follows. First affirmative defense. In an answer, you answer what the allegations, what the conduct is alleged. And you also put up what are called affirmative defenses, which are basically like your excuses for why you shouldn't be found liable for whatever the conduct is. And you'll see how bizarre some of these are given what we know and what we've seen and the evidence that's out there. So the first affirmative defense is a failure to state a cause of action. The complaint and each cause of action contained therein fails to state facts sufficient to constitute a cause of action against the answering defendant. I don't think that's going to hold water. Second affirmative defense, which is statute of limitations. They're trying to say that any of the causes of action alleged in the complaint are barred by the statute of limitations, which I find a little hard to believe because, first of all, it hasn't even been a full year before this was filed. So even if there was a 1-year statute of limitations, it hadn't run. Usually a statute of limitations, depending on the state you're in, because it varies by state, would be, several years. Like it's usually like maybe 2 or 3 years for certain things. And then depending on what you're suing for, sometimes it's even more than that. Third affirmative defense is waiver. These answering defendants are informed and believe, and therein allege the plaintiff by his acts and conduct have waived any right to seek the relief prayed for in the complaint. Again, ridiculous. I don't see how this guy's done anything that would waive his right to sue Jack Doherty. Fourth affirmative defense is comparative negligence. So you'll see this a lot in like personal injury claims or accident claims, and it depends on the state you're in or whatever set of laws is controlling where you file the case. You'll see that people will sometimes allege comparative negligence. So what they're saying is the plaintiff is partially responsible for what happened and therefore should not get the damages that he's seeking. And it says, these answering defendants are informed and believe, and therein allege that plaintiff failed to exercise reasonable and ordinary care, caution, or prudence for their own safety in order to avoid the alleged incident. The resulting injuries and damages, if any, sustained by plaintiff were approximately caused and contributed to by the negligence of plaintiff. Now, if you saw the video of this incident, that's absolutely absurd. This guy is standing there. He's not like going after the bodyguard. And the bodyguard, while this guy is talking, just out of the blue, hauls off and wails him and knocks him to the ground. So I don't see what he possibly could have done to avoid a sucker punch. Now, Jack Doherty's the one who was escalating the situation. So it's not like this guy started it. Not from what I saw anyway. Fifth affirmative defense, they're referring to a civil code. It says the answering defendant's liability, if any, for plaintiff's non-economic damages is limited to its proportionate share of fault. So that code section must deal with comparative negligence. And so they're saying that the percentage that the plaintiff is allegedly at fault for this happening is the amount that the damages should be reduced by. Sixth affirmative defense, negligence on the part of third parties. The answering defendants allege that injuries or damages that may have been sustained by plaintiff were the approximate result of negligence of third parties. For this reason, if plaintiff has been damaged, aside from any reductions of damages attributable to their own negligence, damages must be apportioned among all persons and entities in proportion to their respective degrees of fault. Well, the only two people I can see that are involved here is Jack Doherty and the bodyguard. So I don't know what other third party. You can't blame the person who was throwing the party because they had no control over this and they weren't involved in it. Seventh affirmative defense is latches. The answering defendants allege that plaintiff engaged in conduct that, under the equitable doctrine of latches, prevents plaintiff from obtaining any relief requested in this complaint. So when they're talking about latches, what it means is they're saying that the plaintiff unreasonably delayed making his claim or filing his complaint, and therefore he's not entitled to any relief. I don't see how that's going to fly because the guy filed this within a few months of it happening. So I don't see how that's going to fly. Eighth affirmative defense, privilege. The answering defendants allege that the acts and conduct of answering defendants complained of by plaintiff were at all times privileged under California law, including but not limited to Civil Code Section 47. I looked at California Civil Code Section 47, and it deals with privileged publications or broadcasts. So I'm assuming they're trying to say that privilege applies to the broadcasting of what was happening. Both, I would assume, the live stream and then the recorded stuff that he reposted on social media. I'll be interested to see how they make that argument. Ninth affirmative defense is outside course and scope of employment. So now here's Jack Doherty trying to cover his butt, where he's going to try to allege that what the bodyguard did was beyond the scope of what his duties were. I don't see how that works here, but this is what they're saying, but I don't see how this is going to work. The answering defendants allege that if the trier of fact, that's the jury, should find that any agent of defendants engaged in any allegedly unlawful conduct, then such conduct was done outside the course and scope of such agent's authority. Accordingly, plaintiff is barred from asserting any cause of action against defendants based on said allegedly unlawful conduct. That's going to be hard for them to support, because part of the bodyguard's duty is to protect Jack Doherty. And if Jack Doherty is giving instruction where he says, we're going to fight them, basically, I would say that hitting somebody falls within the scope of his duties, or what Jack Doherty is expecting of him, and what Jack Doherty is basically telling him is going to happen. So I don't think that's going to fly either. 10th affirmative defense is no respondeat superior. And respondeat superior is basically the doctrine of where the employer bears the liability for actions taken by the employee while on the clock, basically, for the company. And what they're saying here is that the defendants allege that if the trier of fact should find that any agent of defendant engaged in any allegedly unlawful conduct, that the actions of the agent were not taken in the furtherance of a legitimate business interest of answering defendants. Accordingly, plaintiff is barred from asserting any cause of action against defendants based on said allegedly unlawful conduct. I think this one also, again, is going to be hard for them to prove, because the action taken by the bodyguard, I would argue, is in furtherance of a legitimate business interest of the defendant, because the actions he took are part of his duties in protecting Jack Doherty. And based on what Jack Doherty said, it was clear that Jack Doherty wanted to fight these guys and was expecting that the bodyguard was basically going to do his dirty work. And so I think that this one fails too. The 12th affirmative defense is superseding negligence. Defendants allege that the alleged injuries and damages of which plaintiff complains were proximately caused by or contributed to by the acts by other persons or entities. The answering defendants are further informed and believe, and therein allege that these acts were the intervening, supervening, or superseding cause of the alleged injuries and damages which plaintiff complains. Thus, plaintiff is barred for recovery. If they're alleging that somebody else did something that caused this guy's injuries, well, it's clear to me that the punch came from the bodyguard to the guy, from what I saw, and that caused the guy to fall and injure himself. I don't see how you can blame somebody else there as a third party for what happened here. 13th affirmative defense, and I love this one, assumption of the risk. Now, assumption of the risk is like, say you go to a go-kart track and get into a go-kart and you're driving around, and of course, you know, there's contact involved with other cars, and they're saying that you assume some risk when you, and usually you have to sign a waiver, when you get into that car, the possibility that you might get injured based on what the activity is. It's the same like when you go to a baseball game. If you get hit by a baseball, a lot of times it's argued that you assume the risk. When you go and sit in a seat, you assume the risk that maybe a ball might potentially come and hit you. So it's basically a way of shielding them from liability. So what they say here is the defendants allege that the perils or dangers, if any, existing at the time of defendant's injuries, if any, were open and obvious and known to plaintiff. Plaintiff nevertheless conducted himself in such a manner as to expose himself to said perils and dangers, if any, and by doing so assumed all the risks attendant thereto. Well, that's absurd. So they're saying that This guy, by being present at this party and with these people, somehow assumed the risk that Jack Doherty's bodyguard might haul off and sucker punch him. That's a little hard to swallow as well. That's absolutely ridiculous. If you go to a party, you don't assume the risk that somebody's going to haul off and beat you. You know, that's not something that normally would happen in a reasonable setting. So the 14th affirmative defense, reliance on reasonable care of others. The answering defendants reasonably expected that the persons giving rise to plaintiff's alleged injuries were using reasonable care, and answering defendants did not have knowledge, nor should answering defendants have known that those persons would not use reasonable care. So I think what they're trying to say is that they had no way of knowing that the bodyguard would use reasonable care in conducting himself. I don't see how that fits here, because the bodyguard basically did what he's hired to do, in my opinion. 15th affirmative defense, no breach of duty. The answering defendants are informed and believe that answering defendants did not breach any duty owed to plaintiff. I don't know if they're trying to say that they didn't owe him a duty of not punching him or causing injury to him. 16th affirmative defense, no causation. The answering defendants are informed and believe that any damages incurred by plaintiff were actually approximately caused or contributed to by the negligence, wrongful and or careless action or omission to act and or other tortious conduct of persons or entities other than the answering defendants. So they're saying they're not at fault for his injuries. Well, you haul off and hit somebody, which causes him to fall to the ground, and he hits his face on the pavement and gets hurt. I don't see how you're not the cause of his injuries, do you? I think this is another ridiculous one. Next one here, it's called unclean hands. Plaintiff's conduct with respect to the matters alleged in the complaint deprived plaintiff of clean hands, and by reason of not coming into court with clean hands, plaintiff is precluded from recovery in the within action. So they're basically saying the plaintiff is guilty of some kind of misconduct or wrongdoing in this whole situation that taints his allegations, and therefore he's not entitled to relief because his conduct was unethical or unconscionable. I don't see how that flies. If you watch the video over where this guy's sitting there arguing with Jack and the bodyguard and, you know, probably responding to Jack's assertion that they're going to fight. And so I don't see where the plaintiff has done anything that could be considered unethical or unconscionable here. The answering defendants are informed and believe, and thereon allege, that if plaintiff engaged in conduct and activity with respect to the subject of these litigation, contracts, and incidents which are the subject of plaintiff's complaint, and by reason of said activities and conduct, is stopped from asserting any claims for damages or seeking any other relief against the answering defendants. So they're basically trying to say that something that the plaintiff said or did contradicts what he's alleging in his causes of action. So, you know, without more information, I'm not quite sure what they're driving at there. 19th affirmative defense, another one you'll see a lot, failure to mitigate. It's like failure to mitigate your damages. And usually it's like when you have a monetary loss. And again, this is more like a contract type thing where, say you're a landlord, and this is like a situation I've encountered where the tenant leaves the apartment, but he still owed rent to the landlord. The landlord then turns around and sues the tenant for the rent that's owed. The landlord usually will have an obligation to mitigate his damages. So in other words, if he was able to immediately re-rent the apartment, like nowadays when there's such a shortage of apartments, he can't ask the tenant who left to pay for months of rent. Like say there were 6 months left on the lease, but the landlord re-rents the apartment pretty quickly, and so 5 of those remaining 6 months end up being covered by a new tenant. Well, he can't sue the previous tenant for the full 6 months. His damages, if you take into account the new tenant that moved in, would only be that one additional month, the 6th month, where he could go after the previous tenant for reimbursement, because you can't double dip. You can't make the last tenant pay 6 months when you got 5 months of those 6 months back from a new tenant. It says the answering defendants allege that plaintiff has failed to take reasonable steps to mitigate its damages, if any. 20th affirmative defense. This is another one that I thought was funny. Unavoidable accident. Answering defendants are informed and believe and thereon allege that any and all injuries, losses, or damages, if any, were the direct and proximate result of an unavoidable incident or condition, and as such were an act of God without fault or liability on the part of the answering defendants. How ridiculous is that? So this guy intentionally hauls off and punches this guy allegedly, but that was an unavoidable accident or an act of God? See what I mean by ridiculous? I mean, I understand that they're throwing out all the affirmative defenses they can, and a lot of times you do that in litigation, but I mean, come on. And here's another one. 21st affirmative defense, consent by the plaintiff. Answering defendants are informed and believe and allege that plaintiff's claims are barred because plaintiff agreed to and or participated in the conduct giving rise to plaintiff's alleged damages. Well, so what are they saying? That somewhere we're going to hear this guy say, come on, punch me? You know, it's not consent if you're just standing there and someone hauls off and sucker punches you. 22nd affirmative defense, ratification. They're really throwing everything in, including the kitchen sink, into this answer. The answering defendants are informed and believe and they are alleged that plaintiff's claims are barred because plaintiff ratified the conduct for which plaintiff now complains. So again, this is like, I don't know whether these attorneys are like contract attorneys or what, but this is another one. Ratification is like when, say you have a contract with another company and certain methods of doing business that occur during the term of the contract are outside of what's specified in the contract, but you basically don't stop or don't protest against the other party doing them, then you're considered to have ratified that. And so if that conduct occurs multiple times and you haven't taken steps to stop it, then you basically have accepted that it's okay for that to happen. So they're basically saying that somehow, this guy allowed the bodyguard to punch him in the past, and therefore he should be barred from suing for him getting punched now. I find that a little incredible. And again, totally ridiculous. Not going to fly. 23rd affirmative defense, good faith conduct. Defendants allege that plaintiff's claims are barred because defendant's conduct was in good faith. Jack Doherty's bodyguard punched the guy in good faith because what? He thought somehow it was okay to punch the guy and didn't believe it was wrong. Yeah, another one that I think goes into the ridiculous column. 24th affirmative defense. Here's another one that is really ridiculous, and you do see this in personal injury cases. Pre-existing injuries. Now, I don't know if you saw the pictures. I'm not going to put them up of the injuries. I find it hard to believe, based on the video of the guy before and after this happened, that they were pre-existing injuries. Answering defendants allege that the injuries and damages, if any, alleged in the complaint were the result of pre-existing injuries and conditions and not a result of the subject incident as alleged in the complaint. Come on. That's just ridiculous. You know, this whole thing, it's absurd. Now, I don't know who these attorneys are, if they're like normally business or contract attorneys, because the defenses that they're throwing out there, most of them are really something you would see in a business agreement dispute. And so here we have the final two ridiculous defenses. The 25th affirmative defense is self-defense. Defendants allege that they are not responsible for plaintiff's harm because defendants were acting in self-defense and reasonably believed that plaintiff was going to harm them and used only the amount of force that was reasonably necessary to protect themselves. Well, that's absurd. If you saw the video, first of all, the size difference between the bodyguard and the guy that got hit is not even comparable. And the guy was not doing anything that looked physically threatening to me, to the bodyguard. So that's ridiculous. And then the last one, defense of others. The defendants allege that they are not responsible for plaintiff's harm because defendants were acting in defense of others and reasonably believed the plaintiff was going to harm others and used only the amount of force that was reasonably necessary to protect themselves. Well, they made a mistake there. It's not to protect themselves. It should say to protect others. But again, ridiculous, because the bodyguard was basically harassing this group of people that this guy was part of, and they all looked like they were equally being harassed. So I don't see how they can allege that that guy that got hit was threatening anybody else. And so that's the answer. I don't see anything in there, in my opinion, that's going to really serve as a credible defense to what happened. My guess is this is probably going to end up getting settled. These types of things usually do settle. I think it would be kind of ridiculous for this to go to trial based on the evidence. I mean, it's so well documented what happened. It's going to be really hard for Jack Doherty to get a jury to believe that somehow there's no responsibility or liability for what happened. You let me know down below what you think. I think it's ridiculous, but I want to hear your thoughts. Now, I want to thank somebody sent us a big bag of dry cat food, but there were no slips in the package. So I don't know if that was intentional and someone wanted to remain anonymous, but whoever you are, thank you so much. The cats love that food. I like that particular brand because it's got a really tiny, they call them kibbles, which is easier for my cats to eat, especially because most of them are older. A lot of times cat food has a bigger kibble, and somehow they don't think that, oh, well, cats have smaller teeth than dogs, and somehow they think that cats can chew something that's almost as big as a dog kibble. But thank you so much for that. Thank you to everyone who sent us stuff from the Amazon wish list. We really, really appreciate it. Also, of course, thank you so much, all of our channel members, for your monthly support, our growing family. Thank you so much also to all of our Patreon patrons. What we get from the support from the channel members and Patreon patrons helps offset the monthly vet bill for the 11 cats that I have. So I'm eternally grateful to you guys for your continued support and for helping me defer some of that cost. I really appreciate it. The cats appreciate it. But anyways, I've got another video coming. Also, don't forget, check out my new channel. I'm going to have the first video ready soon. It's called Sleeping with History. I'll put the link down below. If you would please subscribe to it in advance, I'd appreciate it. But I have another video coming up about a lawsuit that we've been covering. I'm not going to mention it, but you guys, some of you saw my little post in the community page, so you probably know what I'm talking about. That should be coming really soon. In the interim, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.